Justice Burgess.
Would you please call the matter?
Thank you, Judge. Good morning. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Belize, hearing of appeal in CCJ Appeal BZCV number 1 of 2024 between Gulab Lalchand and Rutilia Olivia Supall. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, counsel.
Madam Justice Raj North Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, my fellow Belizeans and all.
Mr. Justice Burgess.
Good morning, counsel.
And Mr. Justice Jamadal.
Good morning to everyone.
May we have the appearances, please? Thank you.
Good morning, Your Honors. Appearing for the appellants in this matter is myself together with Mr. Alistair Jenkins, and for the respondent is Ms. Nazira Oak Miles.
Thank you, counsel. Are there any other appearances?
Not to my knowledge, Your Honor.
Thank you, counsel. So we have received and read your submissions, and now we are prepared to hear you orally. Would you care to start, counsel?
Obliged, Your Honor. Your Honor, this is an appeal that stems from a decision from the lower court, meaning the Court of Appeal, in a division of matrimonial property case. The parties in question were part of a common law union that lasted a little over 8 years. During the course of that union, and before the union, the parties had property, and during the course of the union, they also acquired property individually.
Yeah, just so that we have it on the record, Mrs. Young, could you give us the starting date of the common law union and when it ended, please?
Yes, Your Honor. I could give Your Honors a starting month. It was found in the court below to be August of 2007. And it lasted up to October 2015.
Thank you.
Yes, during the course and even before the union, Your Honors, the parties acquired property in their respective names. From the evidence, in 2011, the parties signed an agreement. Now, Your Honors will note that at various stages of the proceedings, that agreement has been referred to as settlement agreement, separation agreement, nuptial agreement. We say, Your Honors, that nothing turns on the reference to that agreement because the purport and the intent of that agreement will be made clear during the submissions.
Mrs. Young, may I just ask, how did the parties describe it? In their agreement, how did they describe it in the text of the agreement? What did they say about it?
Your Honors, I believe they said it was a, if I could crave your Honors' indulgence, I believe they referred to it as a deed. This deed.
Mm-hmm. So in neutral terms then?
Yes. And that deed, Your Honors, was signed by both parties on the 4th of July, 2011, and it was prepared by an attorney, and both sides gave instructions to that attorney what they wanted that deed to encompass.
Is there any
Now,
evidence as to whether the attorney was the attorney of one party or the other?
no, Your Honor.
No. All right.
To the best of my recollection, based on the affidavit, I think that it was not put in issue whether the attorney was. The parties had discussed that they wanted a document drawn up because they were experiencing marital strife at that time, and they wanted something to memorialize what was to take place in the event they separated. And an attorney was reached out to by the husband, but the evidence of the wife is that she gave instructions to that attorney as well, and those instructions were incorporated in the deed.
Thank you.
Now, during the course of the proceedings, that deed, Your Honor, the courts below had to interpret the provisions in that deed, and in particular, Clause 4. The courts below, Your Honors, also had to interpret what was the intent of the deed, and there was no issue taken by either side that the deed was procured as a result of any undue influence, duress, or that there was not sufficient disclosure, or that there was any mistake. That was not put before the courts below. And so you will find that in the trial judge findings, she found that the deed was valid and enforceable. But where the issue which gave rise to this appeal has to do with the scope of the interpretation of that deed. And Your Honors, in addition, that at the time, if I could just harken back to when that deed was signed by the parties, there were various properties acquired by the wife and various properties acquired by the husband. And that deed included or disposed of, as per the terms of that deed, the properties that the parties had acquired in their respective names at that material point in time. Subsequent to that deed being signed, the parties continued to cohabit or resume cohabitation, and it was not until 2015 that the parties went their separate ways. When the parties went their separate ways, the wife commenced a claim in what was then the Supreme Court to claim various remedies pursuant to Section 148. And if I could direct Your Honor's attention to page 207 of the record. And I have to, as a matter of housekeeping, Your Honor, when we were putting together the record for the Court of Appeal and therefore for this court, Your Honor was provided with an amended originating summons that referenced a court order dated the 16th of February 2018. Subsequent to that amended originating summons, Your Honors, there was another application to strike, and there was a written decision handed down by the learning trial judge where she struck out paragraph 5 of that amended originating summons. And the court order is dated the 13th of March, 2018. But for some reason, Your Honor, in the amended originating summons that was filed, the paragraph 5 was redlined, but there was not a strikeout of that particular paragraph. Nothing turned on this, save that I think the parties acknowledged that that particular paragraph was in fact struck out based on the decision of the learning trial judge, and also that the second respondent at that time, Benzer International Company Limited, the claim was struck out against Benzer as a respondent, but the learning trial judge made an order that Benzer was to remain an interested party in the proceedings.
Ms. Young, can I ask you then, because I have tried to get it, do we have the original originating summons that was filed?
We have not put it before the court, Your Honor, but we can certainly do so.
Yes, subject, of course, to what the president says. Ms. Young, do we have as well the written judgment or ruling that you speak about of the trial judge with respect to striking out paragraph 5?
Yes, Your Honor, we have exhibited that
is here.
ruling.
Yeah. Could you give us the page number and the order as well? Is there a separate court order?
Yes, there was a separate order drawn up by the learning trial judge, Your Honors.
If you could give us those pages, yes.
Yes, crave the court's indulgence. In volume 1, so I think it's volume 2. Crave the court's indulgence, Your Honor.
Yes,
we will get that shortly to you. 722. 701.
And while you find that, that claim was commenced when? You mentioned that as well, Ms. Young, but you didn't give us a date when the respondent commenced the claim. Honor, as you find it, yes.
Yes, 2016, Your Honor. And the matter came on for hearing, I believe it was 2019.
Well, there were other matters before, interlocutory matters, because you said the court order was the 13th of March, 2018.
Indeed, Your Honor. Yeah. There were several interlocutory applications. The decision to which I draw Your Honor's attention was dated, signed by the judge the 27th of January of 2018. And it can be found at page 775 through to 794 of the record.
Thank you.
And the court order that was drawn up, you will note, sorry, Your Honor, there was another application to strike, but an order was handed down, which can be found at page 795 of the record through to 797 of the record.
Thank you.
Yeah.
Ms. Young, once you have dispatched these procedural issues, I think you wanted to get back to the substantive point you're making about the scope of the July 2011 agreement. And I believe that you were about to tell us about the intersection of that agreement with, is it section 148E?
Yes, so Your Honors, I don't know, we have numbered the grounds of appeal. We first dealt with pleadings, and then we dealt with the agreement or the deed and the scope of the deed. So I don't know if Your Honors wish for me to start with the scope or with the pleading points. The pleading points, Your Honor, will assist the court in determining whether the learned trial judge and the Court of Appeal were right to include the Venezuela site property.
We are happy to start, Ms. Young, wherever you wish. Please go ahead.
Guided, Your Honor. So, Your Honor, we would, our preference would be, Your Honor, in the numbering of the grounds. So if we could, Your Honor, start with grounds 1 and 2 in these proceedings, which we've argued jointly. So, Your Honor, it was not contested that this application was squarely made within section 148. And the reason I had invited your attention to the originating summons, Your Honor, is that when you look at the first page of the originating summons, you will see that the only person addressed is Let Gulab Lalchand of Venezuela cite Curazao tongue within 15 days of the service of them, inclusive of the day of service, caused an appearance to be entered. You will note, Your Honor, that Gulab Lalchand was the only respondent in this matter that was named as a respondent, that was a respondent and was asked to appear in this summons in relation to the reliefs being sought. The interested parties were the 4 children to whom shares in Benzer were transferred. And ultimately, after the various interlocutory skirmishes, Benzer, the learned trial judge, changed the capacity with which Benzer was before the court from that of an interested party, that of a respondent to an interested party. Now, it was very clear throughout the proceedings, Your Honor, that based on the summons, the jurisdiction being invoked by the wife was the jurisdiction under section 148. She had named it 148 semicolon 5 and 148 semicolon 9 because as I had explained in the scales, those were the reference for the 2003 edition of the Supreme Court of Judicature Act. You will find in the judgment in the court below that the learned trial judge correctly referenced 148E and 148H of the 2011 revised edition of the Supreme Court of Judicature Act. So there was no mistaking at all that this was squarely an application under that jurisdiction. There was no claim under section 149 of the Law of Property Act. And I will get into the jurisdiction under 148H. And you will note that what the wife was seeking was to set aside an instrument of transfer under that particular legislation as having been made by the husband to defeat an anticipated order. Your honors will appreciate when you look at section 148H, you will see that what is attacked in that particular jurisdiction, that particular provision, is the instrument of transfer. This is to be distinguished from when a transfer is attacked under 149 of the Law of Property Act or 143 of the Registered Land Act. Why do I say this? I say this simply because there are defenses to 149 of the LPA and 143 of the RLA. Those defenses are that purchasers who are equities darling, bona fide purchasers without notice, have a defense to such a claim if one were made for a fraudulent transfer. Under 148H of the Supreme Court of Judicature Act, it is the instrument of transfer that is attacked, and the allegation is that the husband signed that instrument of transfer to defeat an anticipated order. There is not the defense of a bona fide purchaser that one finds under Section 149 and 143 of the LPA and RLA, respectively. Because what the court does is it looks for any transfer by the husband that was made to defeat an anticipated order. Now, in the court below, the learned trial judge found that the transfers of shares to the children were not made to defeat an anticipated order. And therefore, she did not set aside or declare void those instruments of transfers of shares. That particular finding was not appealed before the Court of Appeal, and that, I assume, was accepted by the respondent as a proper finding of the learning trial judge. Now, she therefore did not set aside those transfers. Had those transfers been set aside, then declarations, we say, could be made in relation to those shares. What the learned trial judge did, we say in error, was to, having not set aside the instruments of transfer, she nonetheless, even though the first to the fourth interested parties were not named respondents, were witnesses in the claim, she found that the husband retained a beneficial interest in those shares as to 51%. And we say, Your Honors, that this is where the learned trial judge erred, and this is where we believe the majority in the Court of Appeal also erred, because there was not a proper claim against the first to the fourth respondents, other than the claim under Section 148H of the Supreme Court of Judicature Act, as it then was.
So, Mr. give me one. Okay, so that's 148H, but the claim is also under 148E, which allows a jurisdiction to make declarations of interest in property. So that under 148H, I'm asking you, as you rightly say, the judge found that there was no intention to transfer for the purpose of defeating a court order. Agreed? That's what you said to us.
Indeed,
but then
Your Honor.
you critique the court because the court went on to make a declaration that the husband retained a 51% share in those shares, right? That's the shares in, what's it called? The company now, Benzer, right? Yeah.
Benzer,
So my
yes,
question,
indeed, Your Honor.
yeah, thank you. My question is, could that declaration have been made under 148E? Could such a declaration have been made under 148E?
We respectfully say no, Your Honor. And the reason we say that, Your Honor, is because based on the express wording of 148E, that provision deals with assets, property acquired by the parties.
Or either of them. Or either of them.
Indeed. Thank you, Your Honor. And so when you look at that provision and you read that section in its entirety, you will see 148E, subsection 7, that any order is only binding on the parties to the union, but not on any other person.
No, pause. Before we get there. Your critique is of the declaration of interest. For a moment, let us not get to whether how it implicates third-party rights. Let's not get there as yet. Under 148E, on the evidence, forget about whether you agree with the assessment of evidence. We're just on the question of law. On evidence, could a court have made a declaration of interest in property, which, as our brother explained, has been acquired by the parties together or by either one of them in the consideration of common law assets? That's what this is about, right?
Indeed, Your Honor, but at the time of the hearing, these shares were not in the husband's name. And so
no, I understand. That is why a beneficial interest was declared. So because it was not in the husband's name, does that mean that something, if the legal title in something is not in a person's, a party's, an entity's name, does that ipso facto mean that that person or entity cannot have a beneficial interest in the asset or commodity?
Justice Jamal, if you allow me
Sorry.
as well.
Yes.
I wish to add to the question. Does section 148E suggest at all that the property must be in the name of that party? As you answer the question, Ms. Young, that's all. Thank you.
Yes. Thank you, Your Honor. If I may direct my attention to Justice Jamadar's question, and then I will get to that issue you raised. Justice Jamadar, I just want some clarification before I answer. Are you speaking to the Benzer shares or the assets of Benzer?
Well, the declaration that the court made, to clarify your question, I'm not quite sure for myself what I'm asking about, in the sense that the declaration that the court made was a declaration as to the husband's interest in the shares. Is that right?
Indeed, Your Honor. But one of the reasonings for that was because the company had gone on to do business other than the cigarette business. And that was the reasoning which grounded the learned trials judge's decision. And one must appreciate that the claim against the respondent, the second respondent, Benzer, was struck out. There was a claim in relation to the assets of Benzer, and that was struck out by the learned trial judge, and that decision was not appealed. She then made an order that Benzer nonetheless remain a party, but as an interested party. So that is why she struck out clause or paragraph 5 of the amended originating summons. So she made a finding that no claim could be made against Benzer's assets. What she proceeded to do, we say in error, was without having set aside the instrument of transfer to make a finding that the first to the fourth interested parties held the legal interest to the shares in trust for the respondent as to 51%. And we say respectfully, Your Honors, that that was beyond what was before the court, because the first to the fourth interested parties were not named as respondents, and one cannot, unless there is a properly pleaded case before the court, separate the legal interest from the beneficial interests. And that is where we respectfully say that the learned trial judge erred. And we respectfully say, Your Honor, back to your question, that 148E deals with the assets acquired by the parties or either of them, as Justice Barrow correctly pointed out. It does
so Mrs. Young, I think I understand the nuance. I think you may be agreeing that a judge can make a declaration under 148E. But in this case, because of the way the case evolved in relation to parties, it was inappropriate or wrong of the judge to, you say, A, make the declaration, but even if the declaration could have been made, to then go on and to hold that I call them the paper shareholders, that is, I think the children, held the 51% in trust for the wife, correct?
No, Your Honor.
No, that's not what you're saying.
No, that is not what I'm saying. I'm saying, Your Honor, that the court, there was nothing before the court to have the court declare. There was no pleading against the first to the fourth interested parties to have the court declare that they held those assets in trust.
Counsel.
Yes, Your Honor.
If I may, it may be that the court didn't have jurisdiction on this section 148E1, but what about section 148E3?
Yes, Your Honor, when you're reading these sections, it is our respectful position that they have to be read as succeeding the various subsections to make any sense. So there is reference to subsection 2, and then subsection 2 references subsection 1. So the property that subsection 3, we say, is referring to has to be the property acquired by the parties or either of them during the subsistence of the union.
But isn't this subsection 3 giving the court jurisdiction to alter property interests?
Yes, Your Honor, it does give the court the right to declare and to alter. So, for example, and this was made very clear in the decision of Vidrine and Vidrine, which Justice Barrow, in his former self as a Court of Appeal judge, explained that when the court is faced with a claim, it has to determine the ambit of the property of the parties or either of them acquired. In this case, at the time this claim was started, the shares in the company Benzer was vested in the first to the fourth interested parties. And therefore, at the time the court was adjudicating on this matter, it had to see in the context what property was acquired by the parties or either of them during the subsistence of the union.
So, Mrs. Young, the acquisition during the subsistence is different from the ownership at the time of adjudication. The test is, as you rightly have pointed out, in relation to property acquired during subsistence. Agreed?
Yes.
Right. So that we may acquire something, parties may acquire something during subsistence and dispose of it.
But respectfully, Your Honor,
So, I'm just trying to say that there's a distinction. There's a distinction. It may be that if you've disposed of it to a bona fide purchaser or something, it cannot form the asset base for distribution. I understand that. But the test is in relation to property acquired during the subsistence of the union. Query, were the shares acquired during the let's just answer this for now. Were the shares acquired during the subsistence of the union, before divestment to the children? Were the shares acquired during the subsistence of the union?
Respectfully, Mrs. Young, I'm going to ask you to respond to that question. I believe our sister, Justice Rajnath Lee, perhaps has an outstanding question that you had promised to address. And
I think we've come back to it, President.
Once you have done that,
yes.
Once you have done that, I'm going to invite you to move on to your next point. Thank you.
Yes, grateful, Your Honor. Justice Rajnath Lee, please forgive me, but if you could restate the question. I got caught up in the queries just now.
No. Thank you so much, but I was just saying to the President respectfully that I believe you have come around to it, which is that what is required according to this section, as I see it, is that the property is acquired by both parties, by one of the parties, during the subsistence of the union. So that is what I was interested in, and you have come around to it in your discussion with Justice Jamadar. I am hoping, President, that we can let her just dwell for a minute or two on 148E7, which you raised, Ms. Young, a short while ago. And I think as you continue your answer to Justice Jamadar, perhaps you can just speak briefly to it, because it would appear to me that it contemplates a situation like this, that the person in the common law union does not have to go all over the place, all over the world, looking for other parties, other persons who may be impacted by the decision of the court under 148E. So please have a look at it, please. I'd appreciate that.
So Justice Jamadar's question, if I remember clearly, had to do with the question of the acquisition and whether that property can be the subject of the court's jurisdiction for distribution. And Justice Rajnath Lee wishes you to have a look at 148E7 in this general context. And then we'll try to summarize where we are and move on. And thank you, Mrs. Young.
Yes, so in answer firstly to Justice Jamadar, when you look at 14HE subsection 2, it says, in any proceedings under subsection 1 of this section between the parties to a common law union in respect to the existing title or rights to property, the court may declare the title or rights, if any, that a party has in respect of the property. We say, Your Honor, that when this jurisdiction is invoked, the court has to deal with properties that are in existence. And we say that this, to do otherwise, could create instability in terms of ownership. If, for example, the husband was into real estate and he bought and sell property, you could end up with a situation where he is declared to be the beneficial owner of property he has disposed of. And so we say that when this jurisdiction is invoked, it has to be what is before the court. And it cannot be what has been transferred. And that is why the legislature went a step further and say, okay, if you've transferred, there is that provision 148H, which allows the court to set aside that transfer. So it is our respectful position, Your Honors, that it has to be properties in existence, and there was no previous declaration to this claim that the husband had a beneficial interest in those shares.
Sorry,
Right,
Ms.
so
Maureen,
the shares were transferred. The transfer was not struck down. There's nothing to suggest that the transfer did not include the legal and beneficial ownership in the shares, and therefore those shares ought not to have been the subject of the court's jurisdiction to distribute the property between the parties. Do I have your submission roughly accurately, Mrs. Young?
Yes, Your Honor, you do.
Would you then please answer, Justice Rogers, please, assuming it's different, section 148E7, so we can move on? Is that a separate point? Yes.
Yes, so that subsection, Your Honors, I think fortifies our position that, in fact, any decision, because of the uncertainty that could arise if you were to declare beneficial interests on parties who are not before the court, on assets that are not before the court, it makes it very clear that the order that the court makes cannot bind any third party. And
Ms. Maureen, let me
Yes,
interrupt you right there, because I want to suggest to you that you have just exposed your Achilles heel in relation to subsection 7. You says, if the court makes an order, I suggest to you what this is actively contemplating is that the court may make an order. It binds only the parties to the proceedings, and it does not bind any third party. It is the difference between an order, a judgment in personam, and a judgment in rem. The rest is not affected. The court is not making any declaration in relation to those shares as held by the children that the husband, or sorry, Mr. Gulab continues to own them. The court is not making that in relation to the children. The court is making an order in relation to Mr. Gulab, saying that is property which was acquired during the subsistence of the union. You have disposed of them, and we are saying that for purposes of assessing the rights or interests which you have in them, we, the court, find that you have a continuing beneficial interest. We don't care what the situation may be as regards you and the children in that regard. And we, the court, can make that statement because we, the court, will not make an order in any way affecting the holding of the shares. We will make an order as to Mr. Gulab's interest in the shares purely to determine what assets he has and what assets we, the court, should consider should be available for distribution and for determining what he should give to Ms. Rutilia. How about that?
And just to add to that quickly, 148E3, following that computation, 148.3 allows, does it not, for settlement of different property to accommodate this calculation. So that if you have a 51% in the shares, you don't take it away from the third parties, you compute that. But if Mr. Gulab has other property, you can make the adjustments there. And there is nothing revolutionary about that. This is typical classical matrimonial property law, isn't
So
it,
I think
Mrs.
we
Young?
understand the points they make. Could you just respond quickly to that so we can move on, please? 3/4 of your time has gone, and we have a long ways to go. Please.
Yes, indeed, Your Honor. My response to that is this. I hear what Justice Sparrow has said, but we think that the reason that when you look at the reason why the legislature, there has to be, our position would be, okay, there has to be some previous finding that I have a beneficial interest, or I may be the beneficiary of a trust by a trust deed or a previous declaration of the court. And in those circumstances, that the court would be able to make a finding that that is something that it could take into consideration and pool. And yes, I agree with Justice Jamadar that what subsection 3 does, it gives the court flexibility, because what the court generally tries to do is to make an order for clean break. So as to say, okay, we think this property worth is the value is 400,000, and we think your interest is 399,000. So we will give you this property in substitution of granting you a declaration or an interest, a part interest in those respective properties. So we say that in those circumstances, that is what the legislature contemplated to be done. And when you consider the power of the court to set aside transfers, I think it becomes even more we won't say obvious, but we would say it becomes, it's congruent with what we are saying. So we say that, yes, if there's a trust deed, and there's a previous declaration as to beneficial interest, yes, and that is why we had put before the court the English approach to dealing with assets that are in third parties. The English approach is you try to, from very early on, as was stated in Vidrin, you try to identify the properties. So the court can engage in many trials to determine, okay, and that way the third party has a right to put before the court and to defend any such findings, and to challenge any, and the court could make a determination, yes, we still hold that you hold these assets, you hold them in trust, and the beneficial interest is this, and then bring it under. But there has to be a previous finding, we respectfully say, or there has to be a trust deed that separates the legal from the beneficial interest, because when you read subsection 2, it speaks to existing.
Okay, Mrs.
I
Young,
hope I have answered
Mrs. Young,
the various questions, Your Honor.
I think we understand your position very clearly. You said that there was a pleading point you wanted to have dealt with first. I think you have dealt with it from your point of view. Did you want to move on to the second point that you had in store for us?
Pleading, grateful, Your Honor. The pleading points, Your Honor, are one, as we have said in our written submissions, that the interested parties were not respondents before the court. We say, especially when you look at Mr. Armanani, Shyam Armanani, he was not even made a party to these proceedings, and there was no claim that he held the Venezuela site property in trust for.
But Ms. Marin,
husband. Yes, Your Honor.
Ms. Marin, dealing with the pleading point brings you back to parties. So in adherence to the President's wish that we move on from the earlier discussion, this is now a new discussion. And in relation to the question as to who were the parties against whom what claim was pleaded, Surely what was pleaded here was a claim in relation to this asset. This asset was acquired during the subsistence of the union. And what Ms. Rutilia is claiming is, I have an interest in it. If the court decides that you do not have an interest in it, and that Mr. Gulab has an interest in it, only a beneficial interest, and that is available or accessible for the court's consideration of what order it will make, then how do you get past that? Help me.
Your Honor, we say that for a court to make such a finding, Mr. Shyam would have had to be named a respondent because the legal title was in his name.
But let me interrupt you. The court is not being asked to deal with the legal title. That is exactly the point.
Your Honor, the court was being asked to say that the beneficial owner of that property was the husband. And we say, Your Honor, for a court to be able to separate, if you will, the legal from the beneficial interest, there has to be a proper contest, there has to be fairness in the proceedings, and a third party would have to be heard. He could, in this particular case, Mr. Shyam was only there as a witness. He had no legal counsel, no pleadings were put in place on his behalf, and he was during the ceremony, during the trial, he was on his hospital bed. So we say that court, it is our respectful position.
Mrs. Young, you are talking about separating the legal interest from the beneficial interest in relation to the holder of the legal estate and the claimant or the alleged owner of the equitable interest. The court is not making any determination in relation to Mr. Shyam. It is simply saying, Mr. Gulab, we find you own a beneficial interest in that property. As between you and Mr. Shyam, you can continue on the footing that he owns everything. That is as between you two. We will not, the court will not interfere with that. But as regards the interest that you have accessible, available to be considered by the court in relation to this claim by Ms. Rutilia, we find that you have a beneficial interest.
Your Honor, we say that when you look at the decision of the learning trial judge, she did in fact make a finding that Shyam held the property and that he...
That finding was not binding on Shyam, not binding. 147.
No, it's not binding, but
right.
But Your Honor, we say that we respectfully say that that proposition from a perspective of third parties is very concerning, because you could make, and that third party, in this particular case, Mr. Armanani was a witness, but you could make that mean without naming anybody, without bringing anybody before the court, you could just name and say, I have a beneficial interest in X, Y, and Z that's in. Your Honor, I cannot see how that could, that was what was envisioned by the legislature. I think
without digging too much into your time, let me give you two clear bases for you to now see it. In the case which you rely on so heavily, TL against ML, what took place in that? The wife was asking for a property adjustment order in relation to a particular property. I suspect, we don't know, that she was looking for an occupation order in relation to that property. So what took place? The brother who owned the property was made an intervener. And therefore, there was a claim as between the wife and the brother because the brother's interest would be affected. In this case, Mr. Shyam did not need to be made a party because Mr. Shyam's interest was not going to be affected. The second thing is, I want to suggest to you that the law in England, the rules have evolved where you can get an order against a person, and then if the judgment affects a non-party, you can then serve the judgment, or you can be made to serve the judgment on that non-party and make that party now a party to proceedings as between you, the judgment holder, and that previously non-party. So it is a clear situation contemplated where parties not parties to proceedings may be made parties afterwards because the court can make orders affecting them and then afterwards have them litigate the matter. I can give you the reference if you wish.
No, Your Honors,
You're familiar.
There are, and I will tell you that in Australia, that court is empowered to do that, but there are statutory safeguards to ensure that the third party is able to contest that allegation. So we say that
to the extent that it affects them.
Your Honor, we say that, you know, a proper determination, the court just can't make a declaration as to beneficial interest without fully hearing the whole history of the acquisition, how it was paid, what was, you know, why was the property mortgaged before the bank, how far did Mr. Armanani pay? None of that was before the court. In a proper case where there's a fair and due process and contest, all of that would have been marshaled. But when Mr. Armanani looks at the amended originating summons, he is not asked to answer to that. But yet, you know, and even in fairness to the respondent, Your Honor, there has to be a proper contest. It cannot be that I could claim, for example, if I could just hypothetically say, okay, I make a claim against X, and I say he has a beneficial interest or he is a beneficial owner of XY properties, and those persons outside are not heard any at all. There is no, where is the fairness? Because those persons might be material in terms of saying what really transpired. But if you were simply to say, okay, you're allowed to claim without bringing that party and naming that party, I find that, Your Honor, respectfully, I say that.
I want to say to you to conclude on this part, I am very clear as to your response to my inquiries, and I will not seek to argue the point with you. I have had your submissions in relation to it, and I will guide myself by reference to them. Thank you.
Mrs. Young, you mentioned some pieces of Australian legislation that provide the kind of safeguards you discussed earlier. I can't recall, did you mention those pieces of legislation in your written submissions?
Yes, Your Honor, we did, because in the Australian provision, they expressly say, I believe it's Section 75 of their Family Law Act, they expressly say that the court may direct that a third party appear before them, may make orders in relation to a third party. And in Australia, the legislature have gone a step further. They've even made an order that in making the alteration of property, that they could include property that was previously settled, whether under a postnuptial or antenuptial. So their statute has gone ahead of us to provide for those scenarios, but they've provided safeguards. And so we say that, you know, we understand why they're, and decisions, when one reads decisions coming out of Australia, one has to be very careful because the court, the family court in Australia enjoys express statutory jurisdiction. But we say where they do, where the legislature has so provided, there are statutory safeguards.
And those decisions which are emanating from that legislative landscape in Australia, again, you have mentioned some of these in your written submissions.
Your Honor, we have not included decisions dealing with the alteration of postnuptial.
Yes.
We have not included those, and I don't believe we've included decision dealing with directions given to third parties, so forth. But we say, Your Honor, that the legislature, the language is very clear. And we say, for example, in England, and that is why Justice Mostyn decisions are helpful, because Justice Mostyn has said, you know, when you're dealing with third parties, the judge presiding over these matters, and he gives a 5-step or five rules which he believes that a court should adhere to when dealing with that scenario, to have the third party be joined as early as possible in the proceedings, to have pleadings and the third party be able to contest, to have witness statements and directions very early in the proceedings. And in another decision, Your Honor, Justice Mostyn, and a renowned family law judge in England and Wales, also made it very clear that these were safeguards to deal with properties, and that it was incumbent on the party seeking a declaration as to rights or property that's vested in third party. It was incumbent on that party to ensure the joinder as early as possible in the proceedings. So we certainly, Your Honor, believe that in England, where there is not the express statutory provisions as in Australia, Justice Mostyn, one of the most renowned family law judges, has very clearly said in judgments that have been cited in Radin and Jackson, renowned treatise on family law, and his dicta in those decisions are cited because in fairness to that third party, he has outlined recommended procedure that a family court judge facing those scenarios should adhere to. And he went on in another decision to say it was incumbent on the parties seeking to join.
Yes, I think you made that point, Mrs. Young. Thank you. So
Yes.
Would you then care to move on perhaps to the third major area for engaging our attention, please?
Guided, Your Honor. So the other grounds that we have before Your Honors has to deal with the deed that was signed by the parties on the 4th of July.
Is that what you call the scope?
Yes.
Yes.
We argued both that document as being valid and enforceable, and we have also dealt with the scope, Your Honors. And if we could draw Your Honor's attention, both sides exhibited disagreement in their respective affidavits. But I believe a clear picture of that document could be found. Just crave the court's indulgence.
It's an exhibit to the High Court judgment.
Yes, Your Honor. It's also exhibited there. And just to say that it was in evidence, both sides had put it before the court. The copy that the wife had exhibited is a little dark and hard to follow. And so we we're just simply trying to find a better copy for the court to follow it. So that deed was signed by the parties, Your Honor, and in that deed, the parties, based on the wife's own evidence, was that it was signed as security in the event the parties separated. And that deed, Your Honor, the critical part of that deed, we say would be clause 4. And when you look at the time when that deed was signed, Your Honor, that deed dealt with all the assets that the parties had at the time.
Ms. Marin, let me seek clarification from you on that statement. The deed does not mention Benzer.
Indeed, Your Honor.
So you say it deals with all the properties they had, but Mr.
Yes, Your
Gulab
Honor.
had Benzer at the time.
Yes, and we say, Your Honor, that when you read 4C of that deed, 4C could only have been referring to Benzer.
Oh, okay.
And though not named, Your Honor, in that deed, we say that when you look at the evidence and the cross-examination of the wife, she admitted that the reference to companies included, she gave in and said it included Benzer, because Benzer at the time was the company that was importing cigarettes. So there was no, we respectfully say, Your Honor, there was no mistaking that 4C, by 4C, the parties sought to deal with companies owned by the husband.
But Ms. Marin, how can we go against the trial judge's interpretation that the deed does not dispose of or create any estoppel in relation to Benzer? How can we go against it? Guide me.
Because we say, Your Honor, that the deed was intended, though Benzer was not expressly stated in there. When one makes sense through interpretations and rules of interpretation, one seeks to make sense of that deed.
But Ms. Marin, isn't this a case where you are disagreeing with the judge? That's all. She interpreted it out one way, and you are interpreting it the other way. You need to show us that her interpretation is absurd or cannot stand the test of reason.
But
Yes,
just before you answer that, Mrs. Young, did the Court of Appeal agree with the trial judge on that finding of fact?
There was a, Your Honor, just to say very clear, there was a majority decision in the Court of Appeal.
Sorry. Did the majority agree? Yes, I agree. Did the majority agree with the trial judge on that finding of fact?
The majority.
Are we, if I may, are we
Yes.
certain that that's a question of fact,
Yes.
or
That is
isn't interpretation a question of law? I'm not certain.
Your Honor, we respectfully say it falls squarely within the interpretation of the provision of the deed. And we say that therefore it is a question of law in terms of interpretation.
So what legal principle would help us to reach the conclusion that you have reached?
Yes, so we say, Your Honor, when you look at the background, and the only reason we are inviting Your Honors to look at the background is because Benzer was not expressly named in 4C. And we say, but when you look at the background and when you look at the evidence, it was clear that what was intended was that Benzer was to be included in that. And I don't think in the court's interpretation, if I could correctly summarize what Justice, what the learned trial judge said is there was no dispute that the company that was importing the cigarettes was Benzer. I think her issue was when she interpreted the scope, she said, well, this wasn't to deal with Benzer, the company, the shares. This was to deal with the business. And so she interpreted 4C to say Benzer went on to do other business, and that other business was not contemplated at the time that the parties had signed this deed, and therefore Benzer could be, the shares in Benzer could be included in her adjudication on the 148E. So that's what, if you look at her judgment carefully, I don't think there was any dispute that 4C dealt with Benzer. The issue was, in her mind, Benzer went on to do more business beside the importation of cigarettes. And because it had expanded the business. Sorry, Your Honor?
No, that's an interesting point, and I'm glad my brother Burgess raised it with you, because that was also worrying me a little bit about how to characterize that issue as one of fact or one of law. But if you go down the route of characterization as a question of law, there is the point that the deed refers to specific items of property listed in the deed. And as you have conceded, Benzer isn't expressly anyway listed in the deed. The other point that bothers me has to do with the property acquired after 2011. And in a sense, I think you might have anticipated my difficulty, because you spoke of the separation agreement or the deed, whatever you wish to call it, being made in anticipation of the termination of the relationship. So those are the two things that bother me. One is just in terms of the deed, how are we to be comfortable with the notion that the Benzer shares were included in that deed? And then secondly, what about property that would have been acquired by either or both of the parties after July 2011? I interrupted you because I think you're responding to those concerns.
So, Your Honor, I think that it was clear that the agreement was to provide certainty, because from the husband's evidence, they were having difficulties at that time. I don't think the wife disputed that. And they wanted something in writing. In the event they separated, there was certainty, and to use her word, security, that she would be entitled to what was provided for in the deed, and he would be entitled also. So that this was a wife that had children previous to the cohabitation, and the husband had children of his own previous to the cohabitation and subsequent. So the document, as I understood, based on the background, was to provide for, in the event the parties went their separate ways. Now, I don't think that the learned trial judge disagreed that company is referred to Benzer. I think
Yes, she did. With respect, she did.
She did.
Paragraph
Apologies,
16.
Your Honor, but paragraph 16.
Yes. If you look at the last sentence
Yes,
on the
guided, Your Honor.
page, and then go over from there.
Yes, guided, Your Honor. So I think if I could characterize what she interpreted the contract to say is that the contract was speaking to the business of Benzer on the importation of cigarettes. But I think she was interpreting what that section covered. That section covered the business as opposed to Benzer, the company. One also has to bear in mind, Your Honor, that the claim against Benzer and Benzer's assets was struck out, and that was not appealed. And that is why Benzer was joined, the nature of which Benzer continued after that strikeout was as an interested party. We say, Your Honor, and I don't think that if I could just refresh my view in terms of the Court of Appeals decision. The Court of Appeals decision was sorry, I crave the court's indulgence to just allow me to refresh my this one. Yes, Your Honor, when the majority had to contend with Benzer, the Court of Appeal found that the agreement does not say it was in full settlement of Benzer. So the court did not agree with the interpretation which we had advanced before them, was that the scope of 4C was to cover Benzer.
Counsel, I don't mean to interrupt you, but there's one matter concerning the interpretation of the scope of the deed, which is bothering me. The Court of Appeal thought that words in the recital in the whereas clause should be used in interpreting the terms of the contract. What say you? Was this correct? I mean, could you comment on that approach?
Guided, Your Honor, I will. We say, Your Honor, that when you look at what the Court of Appeal said was because the deed did not have a provision that says it was full and final settlement, that it could not have covered the scope. And the court also had referenced the fact that in the recital, there was a provision that says that the agreement was to govern unless superseded by an order of the court. And when you try to make sense of the deed, Your Honor, you will see that the reference to unless superseded was in the recital. But when you look at clause 4, there is an express provision that it was to be a final agreement. And so we say, okay, we...
Sorry, didn't it say final in relation to the properties listed?
Yes.
Yeah, so,
that is what I meant, Your Honor, and that's why I think the vexing issue is whether it includes Benzer.
Right,
I think there was no
dispute
listed in relation.
Benzer is not
Your
listed,
Honor?
but you say it is to be implied.
Yes, we say that,
Yes.
Your Honor.
It's impliedly listed.
Yes. And so we say, Your Honor, that, the operative part of the agreement in circumstances such as this would be the prevailing provision that would guide a court in its interpretation or any person in the interpretation of the deed. Unfortunately, Your Honor, it was not one of those deeds that went into great details, and it wasn't, I think the parties were at that time had hired and thought they had memorialized what was necessary to ensure that this document provided security and would provide for the distribution and ownership of their respective properties.
Mrs. Young, without trying to intervene between you and my colleagues, could I just advise that 8 minutes are remaining to you to complete, please?
Oblige, Your just as a matter of to flag for the court that when you look at the amended originating summons, the wife also sought an order for specific performance for the 2,000 per container. And we wish to draw the court's attention to the outcome in the court below, where the court said, okay, you're still entitled to the $2,000 per container. There were certain properties, Your Honor, just under this agreement, for example, the Peter August property that still remains in the name of the wife. There's another 25 acres that still remains in the name of the wife. The court said, okay, wife, you're only, and we think it's beyond the scope. The judge said, you're only obligated to transfer the Peter August if you get this money from the respondent. We said that the deed did not say that. If the court is going to enforce the deed, which the court made an order specifically enforcing provisions of the deed, that to make such orders would be to vary what was the deed that it was seeking to enforce. But that aside, Your Honor, given the limitations of the time, right. So we ask Your Honor to pay attention to the order given in relation, and what was being sought was in relation against Benzer. We also, Your Honor, given the limitation of time under ground 6, we commend our arguments in relation to grounds 3, 4, and 5. believe we've covered those, but in relation to ground 6, Your Honors, we think that when you look at the valuation that was done, and this is why we say, you know, had there been a proper contest, there would have been a duty to disclose. So that we say that in addition to what we've said at paragraph 45 dealing with ground 6, that it was tempting to say that there was a duty to disclose, but had Shyam Armanani been a party to this matter, or even an interested party, the court could have made an order for disclosure and so forth. But given what we've argued before, we say it was not even properly before the court, and the court was hamstrung from finding out what were the values of the Venezuela property and the shares.
That matter came up, Mrs. Young, in the Court of Appeal, and the judge giving the majority opinion addressed it in a particular way, as I'm sure you are aware. How would you respond to how the judge addressed that problem?
Your Honor, we would say that, you know, when you're dealing, the normal process is that there is some valuation put forward before the court in these matters. I think because of the nature of the claim and the way it was pleaded, there was not a proper valuation put forward before the court, because I don't think the parties understood that the court would have you know, gone on to make a valuation of, in particular, the Venezuela property. The court tries to use a best evidence scenario in these situations and tries to, based on whatever is before it, to come up with a reasonable value. In this particular case, Your Honor, the value for the Venezuela was extreme. It was between 275 and 500, an outlier figure, Your Honor. And, you know, we respectfully say that when a judge is faced with that, I mean, there was case management that orders could have been made, but to simply you know, make the findings with which she said, we say respectfully that she was, we use the word arbitrary, but we do use it with the greatest of respect for the judge. And we cite a quotation from Webb and Webb, Your Honors, which we say it is not permissible for a court to convert an open-ended speculation by one party into findings of fact against the other. So, you know, it's unfortunate the way the matter transpired. Normally in these proceedings, the parties try to put together a valuation, or the court in case management have the parties agree to a valuation or direct valuations on their respective part in a proper context as to these assets. But I suspect that did not take place, Your Honor, and the court was trying to use best evidence, but we say that it was a bit extreme in the way it was, especially with the Venezuela site property, and there was
if we were to, sorry, Counsel, but if we were to agree with you on this point, but disagree with you on the others relative to the property, how would you suggest that we proceed?
That's a very good question, Your Honor. And
it has to be, it was asked by my brother.
Yes, indeed, and it was something the court grappled with below, Your Honors. We just, you know, just based on experience, I don't, you know, and what the court did below was to just use the best value that it could possibly ascertain. based on whatever was put before them, Your Honor.
But
I
Ms.
don't know
Morin,
that. Yes, Your Honor.
Webb and Webb is a very clear case where it is accepted that a judge can only do the best they can in the circumstances. Very clear.
Yes, Your Honor, and you know, we don't disagree too harshly on Webb and Webb. We just thought that what was before them was extremes. No, I'm being very candid with the court on that particular ground of appeal, but we do agree that a court has to make the best in a scenario where the evidence is paltry, based on what is marshaled before them. So to that extent, Your Honor, we say that Webb and Webb is correct and could be applied in a situation like this. We only say that, you know, had this been a proper contest, including, you know, the Shyam Armanani property, more could have been ordered against Mr. Armanani or the parties, the other parties to this matter, because what the court was left with was extreme figures and trying to grapple with it. So I would say that, Your Honor, in conclusion to ground 6.
Was there any duty, Ms. Young, on your client in this type of matter?
Your Honor, when we looked at the pleadings and we looked at the situation in this matter, you know, in our mind and in our defense, we thought that Benzer was completely addressed under 4C. And the wife did seek some disclosure, and I think that in the courts below, it was found that the records were not properly in order for Benzer. Was one of those companies that was had proper accounting records or had been audited. And so what the court was left with was just some records by, I believe, Mr. Manzanilla. In relation to the Armanani, Your Honor, we had taken the position that, you know, this was not, we had been flagging it from very early on in the affidavits that this Mr. Armanani was not a party, and so we had taken the position that in relation to that, there had to be a properly pleaded case and to be a proper contest, and in those circumstances, it would have behooved the parties to apply for a proper valuation.
Okay, Mrs. Young, did you want to have any final concluding remark, please?
No, Your Honor, I think that we have addressed the issues. We just wish to rely, Your Honors, on our written submissions, both the one of the 7th of June and the one in reply.
Wonderful.
In support of this appeal.
Thank you very much indeed. And we have been able to follow you with giving you usual clarity in these matters. Thank you. I would invite the court to stand down for 5 minutes, take a 5-minute stretch break, and we will resume at 12:38. Madam Deputy Registrar, would you be the custodian of that arrangement? Thank you.
Yes, Judge. Court adjourned. Thank you. Thank you, Your Honors. Court resumes.
Thank you, Madam Deputy Registrar. I see my colleagues are back. I see counsel is back as well. Thank you. So, Ms. Miles, we are ready to hear you, ma'am. And although the order said 60 minutes, your opposite basically had 90 minutes. And therefore, you also have 90 minutes should you require those 90 minutes. So please, we're ready to hear from you. Thank you.
Much obliged, Your Honor. I don't think I will be needing the 90 minutes unless questions take me to that point. But if it pleases you, I have addressed my written submissions and will address the court in the like manner. The three main headings, which are the grounds as to pleadings, and then the interpretation of the July 2011 agreement, and thereafter what we submitted in our written submission as the quantification of the award that was given to the respondent. Our main point as it relates to the grounds, ground 1 and 2, as to the issue as to the pleadings of trust against Benzer and the interested parties and Mr. Armanani, we say that these parties did not need to be added as parties to the claim for the judge to have made the declarations and thereafter alterations to the property rights that she did as between these parties to the common law union. We say that because her orders did not affect these third parties' rights, her decision or her declarations were properly made and were found in law. The basis, or we say that the legislator must have foreseen that there would have been circumstances like the present one, and as such, our reliance is heavily placed on Section 148 E7, where it is clear that she had the authority to make the orders and declarations as she did, which would only have affected the parties to the present matter that was before her. So we say that the rights of the first of fourth interested parties, the children, and the legal rights of Mr. Armanani were not affected in any way by her declarations and her orders that were made.
So, Ms. Myers, just to ask you something, from your perspective, there can be no enforcement taken by your client against the third-party rights.
Correct. There's no ability to enforce, only against the respondent. In these circumstances, the appellant, who would have been the respondent.
For the value of his declared interest in the different assets.
Yes, Your Honor.
Oh, okay.
And we say that the approach that the judge took, which was to decide what were the assets that were there for her consideration, those that she considered and determined were outside the 2011 agreement, which in these circumstances were the shares in the Benzer company and the beneficial interest in the Venezuela site home. Once she made the determination that those fall within the pool of assets for her consideration, she then moved on to make a determination of what shares, if any, the appellant had in those assets. And it is based on that determination that she then went on to consider the evidence, which we say is fact-based, as to the evidence of the respondent in this matter, the appellant and his daughter, to determine what were the circumstances around the shares in Benzer and the Venezuela site home, for her to then determine what share, if any, she would have allotted to the respondent in this matter, only in the percent that she determined that the appellant had in those assets. And we say that it is proper because from the evidence that was before her, there were similar circumstances. And I give the court the example. Before the appellant had transferred the shares to his children, he held 9,000 and 1,000 was held by friend or a business partner, Mr. Jackson. And from the evidence, it was clear that it was those shares were just in Mr. Jackson's name because they needed 2 directors or 2 shareholders. But it was clear from the evidence that Mr. Gulab retained full control, made the decisions as to the company. And we say that the circumstances the judge found were the same. Although shares were transferred to the children, she went in to examine what evidence was there, and she concluded that he still maintained, he managed the company, he still made decisions.
But, all right, but Mrs. Miles, yeah, I understand that. Did she make a declaration as to trust?
I
That
don't
the
believe she
share,
did.
so there's no declaration that the shareholders hold the shares in trust for your client's interests.
No, Your Honor.
Right? So that even in relation to the shares in Benzer, there's no enforcement against the legal owners of the shares.
Correct. There is no enforcement.
Similarly with the Venezuela property.
Yes, Your Honor.
Sorry, before you move on, Counsel, you said that she made a declaration in respect of the shares which were still with the first and the fourth interested party. Were they on the share register as the shareholders of the respective shares?
Yes, Your Honor. The children were on the register as the shareholders.
And the beneficial interest, didn't it go with the legal interest?
It's our position that there was some beneficial interest that very minimal passed along with the children, but that Mr. Gulab, based on the evidence that was before the court, maintained the control beneficially, although the children were there. So we say that they were shareholders, but
yes,
just
but
paper
Counsel,
shareholders.
Counsel, does maintaining control, does that have anything to do with the beneficial interest in the shares? I thought that the question which my brother Jamadar raised with you is a very important one. Was a trust declared? But were the first to the fourth interested party trustees? Were they declared to be trustees?
No, Your Honor, they were not declared to be trustees. And if I may proceed to answer Your Honor's question, it went beyond just managing or controlling the company. There was evidence that he was able to, he was receiving monies from the company.
But that's not an incidence of shareholding, is it?
Not shareholding, no, Your Honor.
That's not evidence that he owned the shares beneficially or otherwise. The fact that he was controlling the company, this has to do with the management of the company, doesn't it?
We say respectfully, Your Honor, that it goes beyond just managing the company. The way the evidence was presented to the learned trial judge, and this came from Mr. Gulab himself, as well as his daughter, who was one of the interested parties, he made major transaction. He even bound the company when he entered the agreement with Mr. Armanani's son.
Miss Miles, before you go further to the other property, just direct us to what the trial judge said about the shareholding. And I think just my brother Justice Burgess is saying it cannot be management, but ownership of the company. Direct us there, please, to the trial judge, and then to where the Court of Appeal, the majority, agrees with that, please.
Yes, Your Honor. Favorite judge. It is paragraph 38 of the learning trial judge's decision. It would be page 754 of the record. It starts at paragraph 38, but she continues in paragraph 39 and 40 to examine why she considered that he held a beneficial interest in the shares. It's from paragraph 38 to 41. Her conclusion really is at 41, where she outlines why she determined that he held a beneficial interest.
We understand that, but does her reasoning answer the rather piercing questions, if I may say so respectfully, raised by Justice Burgess?
Your Honor, we say that it does. We say that there was sufficient for her to consider, and she considered that there was a beneficial interest. I can't say that she addressed her mind to the issue of whether they were held on trust, and there was no determination made to that effect. But we say that her having determined, and I hope I'm answering your question, Your Honor, her having determined that these shares fall to be considered in the pool of assets, she could then make the determinations that she made and needed not to have found that they were held on trust for the appellant.
Yes. Well, no doubt Justice Burgess will intervene if he considers it necessary, but I thought he was even looking at the issue of management, for example, or to some extent benefits received from the company, and drawing a distinction between those situations, possible distinction, and having a beneficial interest in the company. So I was just wondering what those paragraphs to which you alluded answered that critique.
Yeah, further to the President's observation, one would have thought that to find that he had a beneficial interest, he would have to be voting the shares, receiving dividends, and or receiving dividends via the shares. But certainly control of the management of the company and using company assets and so on could scarcely be described as incidents of shareholding. Am I right?
We appreciate your position, Your Honor, but if we may, I may respond to say that I think in the circumstances, the way the company was managed and what was put before the learned trial judge, it was in those circumstances that she had to make the consideration. And I say that to say that there was evidence that the company was not, we would say, had proper books of accounting or a proper mode of operating. The evidence was that it was mostly cash-based. Mr. Gulab made most of the decisions. The daughters, while they are shareholders on paper, did not really participate to a large extent in the business of the company. They had just reached or attained the age 18, I believe one was, and it was later in 2015 that they then physically went to the store to deal with the business of the company. So we say that in the circumstances, the manner in which this company was established or operated, it is based on those circumstances that the judge made the finding that she did. And we say, humbly submit respectfully, that in those circumstances and the facts that she had before her, that it is based on that she concluded that these actions by Mr. Gulab were sufficient to declare that he had a beneficial interest.
Thank you.
You will say as well, Ms. Miles, that unlike criminal law, where similar fact evidence is limited to particular circumstances, it was obviously the history as will have emerged before the trial judge, that Mr. Gulab was very fond of having situations where properties, assets, etc., were held in trust for him. Isn't that the case?
Yes, Your Honor, and I was going to get to that point when I dealt with the Venezuela site home, which the legal principle I'm applying to both Benzer shares and the Venezuela site home is that same issue, and that is why I raised the issue that previously the shares were in Mr. Jackson's name, and that did not stop Mr. Gulab from being although he had 1,000 shares, he was also the beneficial owner of those 1,000 shares, and it was his evidence as well as the respondent's evidence that he managed the company how he pleased, he entered business transactions how he pleased, and Mr. Jackson only served as a paper shareholder. So as we use that example, we were saying that in these circumstances, the daughters really served only as shareholders on paper. And to draw to that point you raised, Your Honor, even with the Venezuela site home, we say that it is our humble submission that the learned trial judge accepted the respondents in this matter's evidence that it was an intention to purchase the property. Legal title was not yet transferred to Mr. Gulab, but that was the intention of the parties. Therefore, his renovations, which she says went beyond that of just a tenant, the payment of the remainder of the mortgage, the $1,000 rent that no one knew who it was being paid to, all these monies went beyond what a normal tenant would have invested, and we say that that supports the conclusion that Mr. Gulab has had the practice that other persons may be legal owners on paper, but he retains an interest. And it is even shown in the situation with the Peter August property, which is subject of the agreement, where the bank was selling the property, was in his name, and he asked the respondent, Ms. Supall, to purchase it in her name, and then he would get it from her. So the Peter August property is in her name, but he held the interest, the beneficial interest in it. So we say in the circumstances, we say that the evidence has shown that, I don't know if I want to call it a practice, but it has become a custom that he has persons, third parties, as the legal persons on title or holding the shares, but that he retains a beneficial interest in these assets.
Was there ever a declaration by any court that he had a beneficial interest in any of these properties you speak of?
No, Your Honor.
Thank you.
Ms. Gulab, can I just ask you a kind of incidental question? Suppose you succeed, how do you enforce this? You can't do anything with the shares. You can't do anything with the Venezuela property. Let's suppose at the end you succeed on everything. You therefore get a monetary sum, right? You get a monetary sum which your client is entitled to and for which the respondent is accountable to you for, correct?
Yes, Your Honor.
But you are saying, sorry, you go on.
Yes, Your Honor, that's a point we wish to raise. Because it's a monetary award, we say that the enforcement does not necessarily has to be against the shares or against Benzer or against Mr. Armanani. Mr. Gulab has different assets and there are different methods of enforcement.
No, well, I just want to clarify. You say it doesn't necessarily have to be. Can it be on the state of the court, right? Yeah.
No, Your Honor.
This is part of something that is unsettling for me. And you have said it, I think, at the beginning of your submissions, and it has been the subject of discussion before, which is that, okay, the court can declare that the appellant has a beneficial interest in a property, but that does not affect and is not binding upon somebody else who owns the legal and perhaps beneficial interest in the property. Now, for us lawyers, that may make sense, but I suspect that for persons watching this, it might be a little difficult. So can you explain to me how that works? The court is holding that the appellant doesn't have the legal title to the property, is not the owner to shares, but has beneficial interest in the property or in the shares, as the case may be. And is acknowledging that this other person has legal ownership and possibly beneficial ownership, but somehow is saying that the identification of beneficial ownership in the appellant has no effect whatsoever, and that declaration is not binding whatsoever on the legal owner of the property. Can you explain to me how that works?
Yes, Your Honor. When I said it would not affect the third party, I meant this order that this learned trial judge made. Her orders are only as against the respondent and the appellant in these proceedings. So although she made an order that may affect a third party, for example, Mr. Gulab, that he retains 51% beneficial interest in the shares, it is not a situation where Mr. Gulab can just go and tell his children, I have a declaration that I have a beneficial interest. He would then need to take this order or the order that was made in his favor and commence proceedings against that third party if he so wishes.
But with respect, counsel, it is not where Mrs. Young's point comes in, because what is the basis for making that kind of declaration in the absence of the legal owner being a party to the action? Surely there must be a process whereby the court disentangles the beneficial ownership and then assigns what portion it wishes, thinks appropriate, to one person or the other. But to say that somebody is the beneficial owner of a property in circumstances where somebody else is the beneficial owner of the property, and say that these two things are unrelated, I am just having a little problem with that. Do you understand my difficulty?
Yes, Your Honor, I do.
It seems to me, Mrs. Miles, that your best answer would be to indicate the orders made by the High Court, which is, having made these declarations that Ms. Rutilia was not interested or did not have an interest in the Benza shares, nor did she have an interest in the Venezuela property, but that Mr. Gulab had the interest, the court went on and made the order which is dispositive in relation to these matters. Pursuant to section 148E3B, etc., the court finds it just and equitable to make the following order requiring the respondent to make a transfer of property for the benefit of the applicant. And it goes on, shall pay $240,000. The sum is to be paid within 6 months, may with the consent, this paid in certain ways, etc. And therefore, the dispositive order, the enforceable order made was only in relation to the payment of money. Is that not your best answer, Mrs. Miles?
Indeed so, Your Honor, and that is what we placed in our written submissions, which the court has before it, that is the main point that we have put before the court, that it is a money judgment that was made, and it is only against Mr. Gulab that it can be enforced. So that is right.
Mrs. Miles, I am still troubled, because that order made by the court is based on certain assumptions. And those assumptions include the location of beneficial interests. And they also include the fact that the location of those beneficial interests has no effect on the beneficial interests of others. And I'm saying that logically, I'm having a difficulty with that. And I'm hoping that you will help me with that difficulty. You see, when we talk about the transfer of property, for example, I assume the underlying assumption is that there is property to transfer. Now, if the property is not vested legally or beneficially in the appellant, how is that property subject of the jurisdiction of the court? It seems to me that there has to be a process, and I suggest that perhaps Mrs. Young was articulating this very well earlier, whereby there is a decision-making avenue for the court to identify the property that is to be the subject of the transfer. And she referred us, I think, to procedures in Australia by statute, procedures in the UK, in England by common law, that allows for that process to unfold. So aren't we jumping ahead by saying, well, okay, there's this order and therefore you can enforce it as a money judgment? Surely there's a preliminary point that has to be reckoned with, which is how do you identify the property that is going to be the subject of the transfer?
Sorry, my brother, could you help me? President?
Well, I was hoping to interact with counsel. I don't know whether they wish us to interact here. I think deliberations might be a better place for that, with respect.
Okay. Just that I don't understand when you were referring to the transfer of property, what transfer your question spoke to, but it's all right. I can withhold the question.
Thanks.
Yes, to respond. Yes, Your Honor, to respond to you, I will do as best as I can with the position that I maintain.
Thank you.
You made mention that there were assumptions that were made, and I wish to differ in the use of the word assumption, because I say that there were facts, evidence put before the learned trial judge, and I say in these circumstances it's a bit particular, or it is different than when third parties had no knowledge or did not participate in the proceedings. And why I say that is because although there were only interested parties, the first or fifth interested parties did give evidence, did file affidavits and gave oral evidence. And so did Mr. Armanani. Although they were not listed as respondents, we submit that they did participate and give evidence in these proceedings, and that in looking at the entire picture, that is what the learned trial judge did to make her determination. And I repeat my point that it is our humble submission that there was no order to transfer any property, that her determination, we do not shy away from it, yes, affects a third party to the extent that she made a declaration that there's a beneficial interest in favor of the appellant. However, we say that her orders, which are binding, finds basis in the legislation under section 148E7, where there are orders that were made pursuant to 148E, subsection 1, 2, and 3, and there is clear provision where we say her orders can be made the way she made the orders, that having made the declaration of the beneficial interest, that she restricted herself from affecting the rights or the entitlements of these third parties by converting it to a money figure judgment against a person who is a party to the proceedings which are before her. And we say that rightfully she had the ability to make that order against him. So those are my submission in response.
I follow you very clearly, counsel. Thank you very much. Thank you. Thank you.
Much obliged, Your Honor.
Did you wish to move on from that point?
But can I just
Yes, Your
clarify
Honor.
one? Can I just clarify one thing, Ms. Miles? It's a very short point. I think I know the answer. The interested parties, did they ever make applications to intervene and or join? Because I think joinder runs both ways, right? You can have a party applying for other people to join or be named, and you can have third parties asking to intervene and be joined. So did these interested parties who were aware and had notice of these proceedings, did any of them make applications under the rules to become parties?
Your Honor, to answer you, I was not counsel on record at the High Court, but based on the record, I do not see any applications that were made.
Okay, thank you.
Unless any of your honors have any other questions on that point, if I may be allowed to move on.
Please.
Yes, Your Honor. So the next point we wish to make is in relation to the 2011 agreement, which was titled a deed, but we refer to it as an agreement. We say that this agreement is very clear in its express terms, and it is our submission that it did not include the shares in Benzer International Company. The deed itself under Clause 4C makes it specific that this deed is final, it's the final agreement in relation to the properties which are listed there. And to understand the agreement and the way it was drafted, we say that it is unavoidable that the learned trial judge had to consider the circumstances around when the deed was made, why the deed was made, and what was the business or the properties that the parties had or were transacting at that time. So we say while the interpretation of the language of the deed is a legal principle or a legal issue, there was consideration of fact by the learned trial judge to be able to determine or interpret that it did not include the shares in Benzer. And we say this because at the trial before the learned trial judge, it was not disputed, the evidence that was placed before the court in the first affidavit of Ms. Supall, where she explained what led to the drafting of this agreement. And if I'm allowed, at paragraph 55 to about 58 or 59 of that first affidavit, she explains that when she made the purchase on behalf of Mr. Gulab to purchase back the Peter August Street property at the auction, he kept insisting, when will you transfer it to me, back to me? And she said, well, listen, if you don't trust me, go and get an attorney to draft it. And it's when he started to draft these terms and conditions as to what she has to do, she said, well, let's put in there what you have to do to me, in your obligation to me. And we say that that is how this agreement came about. It is not denied that it's a binding and valid agreement, but we say that at the time the agreement was made in 2011, both Mr. Gulab and Ms. Supall in their evidence before the court agreed that Benzer, the company, it was just paperwork that was in place. There was no actual business established or a store in the free zone or a location where it conducted business. So at that time, one of the transactions it did, yes, was the importation of cigar. But Mr. Gulab also indicated that he did importation of cigar with some Guatemalan clients, and that was his evidence. So we say that what...
Counsel, if I may,
sorry, yes,
sir. Is it permissible in interpreting a contractual document to look at the parties' pre-contractual negotiations and so on? Is that permissible?
We say, Your Honor, that when the learned trial judge it was placed before her to interpret whether it included Benzer or not, that it did, that she was allowed to do so.
Except that the authorities, I don't think, as far as I know, don't support that. But there's a decision of this court, or decisions of this court, on the interpretation of these contracts. I think that what they've done is to make clear how they're supposed to, the principles which are to be applied. Is there any reason why these aren't cited before the court?
Not necessarily, Your Honor, but our position is, if I may, that she needed not to go beyond what's in the agreement. As you will see in our written submission, we say Benzer is not one of the assets that is listed there. And we say that the agreement is specific as to the properties that are listed, and we're saying that the cigars itself is what was being dealt with in that section. So really and truly, our submission is that there needs not even to say that the judge needed to look at the section of it where it says unless superseded by a court, because there was no need to go that route. Our submission is that on the plain language of this agreement, it could not and it did not include Benzer and the shares in Benzer.
Mrs. Young indicated in her address to us that Clause 4C was under litigation before, of course, and that your client, under cross-examination, if I heard her correctly, admitted that Benzer was included in Clause 4C. Is that something that you admit or not?
No, Your Honor. We say that I don't believe that is what my learned friend said. I believe, if I may, she indicated that Benzer was the company who at that time imported cigarettes. That is what was admitted by Ms. Supall during cross-examination, that Benzer is one of the the main company that was importing cigars, but not that the agreement meant that it included Benzer, the shares and everything.
Yes, I'm sure if I'm wrong, I will be corrected later on. The $2,000 per container compensation to your client, was that related in any way to the operations of Benzer?
We say no, Your Honor, and that there was sufficient evidence to demonstrate that the actual business of Benzer commenced after this agreement was signed. There was a store set up in August, September of 2011, and thereafter there were properties purchased by Benzer in Turnef Island and different business in further wholesale, but also retail. But all this business by Benzer commenced after this agreement was signed.
Yes, but the agreement contemplating that there would be business conducted by Benzer, you would concede that?
No, Your Honor, we disagree.
You would not, right? I absolutely understand you. You know, I just look at it from a sort of, again, commonsensical point of view, and I'm open to persuasion. Believe me, I am. But I'm just wondering if the two parties are intending to go their separate ways, as of course is recited in the deed. Isn't the more natural conclusion, or don't say interpretation, that they meant to deal with all of their properties? I mean, why would they deal with some and not others if they wish to make a clean break of it? Of course, as we know, they did not. They cohabited for at least 4 years after. But if that was the contemplation, why would they want to deal with some of the properties and not others? Can you help me there?
Okay, Your Honor, our submission in response to your question, Your Honor, is simply that at the time the agreement was signed, the business that the learned trial judge contemplated in making her award in terms of Benzer did not exist. So at that time, what really existed was just Benzer on paper, a shell, and this came out in evidence during cross-examination. The paperwork was being finalized, and what was really being conducted at that time was simply the business of the importation of the cigars. So we say that it did contemplate the business and the assets the parties had at that specific time when they were going their separate ways. But we say the judge then went on to consider and included as a part of the assets that she awarded under Section 148E what transpired thereafter when they remained together and did not separate as was contemplated. So we say that what she considered under 148E is assets or properties that came about after this agreement.
Yes, yes. Well, thank you for that, because when I read the recital, it does talk about settling their rights and responsibilities amongst each other, which I took to be a global statement of intent, you know, not just what was listed. But I hear what you say. Thank you, Counsel.
Grateful, Anna.
Ms. Myers, before you go on, as a question of law, this case raises a kind of an intersection where parties living in a cohabitational relationship come to an agreement to settle their affairs, but then don't separate, but continue living in a cohabitational relationship for, I believe, a little over 4 years or something like that. In the context of cohabitational relationships and Section 148E, there are other sections that follow that have some bearing, but for now, what is the legal relationship between, I don't know what is the right term, deeds of separation and rights of cohabitants under the law? In other words, is it that Section 148 speaks about court going through a process in relation to property acquired during the subsistence of their union? So suppose before two people entered into a common law union, they came to an agreement. Let's suppose it was a completely free agreement that they would do A and B. Does that supersede everything else that may happen that could be reviewed under 148E? That's one theoretical possibility, right? That is to say, you have an agreement before you start the common law relationship. That's a pure prenuptial in matrimonial law, so to speak, right? You can have what happened here, an intervening agreement in the middle of a relationship. Well, not quite the middle, but you know what I mean. And what is the impact of that? Have you addressed your mind to that question? That is to say, what is the legal status of, I'm calling it separation agreements. That may not be the most elegant expression for cohabitational relationships, but separation agreements in the context of the law of cohabitational relationships in Belize.
Yes, Your Honor. I have addressed my mind to the question you are raising, and we say that in terms of agreements between parties to a union, there is a difference in the Belize law between married persons and the current situation where they were in a common law union. And we say that the Married Persons Protection Act has a specific section in there where it deals with terms such as settlement agreement or settlement in terms of married persons. And we say that the present case, which is before Your Honors, falls outside that scope. So we say that what should be applied to this agreement is contract law, pure principles of contract law. But in making her consideration, the learned trial judge rightly addressed her mind, and we say she should have considered this agreement when making a determination under 148E as to what assets are there. So to break it down, Your Honor, we say that she did give validity to this agreement and she did not interfere, we say, with any of the properties that are listed here in trying to make any declaration or to alter the rights of the parties as it relates to these properties. So she did address her mind to it and she gave it the validity and made it a binding agreement. But she also went on to consider other aspects of assets and that.
So Paul, just pause a minute. I think I made a note. I think you are saying that in cohabitational relationships, pure contract law applies for the purpose of separation agreements. Is that your position?
Yes, Your Honor.
Do you have any authority that supports that?
Yes, Your Honor. We cited in our submissions. Criminal Darling should just get the name of the case. It is a Belize case. It can be found at paragraph 16 of our submissions.
Yeah.
And it is tab 5 of our submissions. I know it is only a high court judgment, but in that judgment, Justice Young explains whether prenuptial agreements or these types of agreements are enforceable in Belize, and she makes reference to a number of cases, including a case from this honorable court, Rumble Hall versus Rumble Hall, and explains what the implications are in terms of the law in Belize in terms of these types of agreements.
And you cite that to us as, from your point of view, a correct statement of Justice Young's analysis and application to common cohabitation and relationships. You commend that to us. You agree with what she has said. Okay, good.
Yes,
right.
Yes,
So the difficulty in this case then for the other side is in a sense that it was not properly drafted. It did not, for example, mention expressly Benzar.
Yes, Your Honor, that's what we're saying.
That's what you're saying. So that as far as you're concerned, Ramda Hall is applicable, as you say, the judge said. But she's concerned about not what was included in the deed, but what was not included in the deed, including Benzar, including the Venezuela property. Yeah, I understand you. Thank you. Anything else?
Not on this point, Your Honor, unless there's any other questions on this point.
I see nothing from my colleagues, so I think you're free to go forward. Thank you.
Much obliged. On the final point, Your Honors, we say that the learned trial judge's method of determining the quantification of what entitlement the respondent was awarded, we say is fair and equitable and just in the circumstances based on what she had before her. And I make reference to the case which Justice Barrow raised with my learned friend Webb and Webb, where the approach that the learned trial judge in these circumstances took is acceptable, and we say that it is not plainly wrong where the court needs to interfere with her finding. She, in her judgment, and I can take the court to the paragraph, where she says this is a company that has no proper method of how accounting is or any books. I have to go by what was disclosed by the interested parties in terms of a value. And that's how she came up with the value and determined based on the value of the shares. And what she determined was the retention of a beneficial interest by Mr. Gulab, determining what his percent is, and then turned it into a money value. We submit that she did the same with the Venezuela site home, where there was a loan to the legal owner's son in the sum of $400,000 or thereabout, and it was mortgaged for $275,000, and she weighed what Mr. Gulab had paid as the remainder of the mortgage, $68,000, I believe, and all his renovations in the sum of $30,000. So we say that the sums that she had before her, she created a range in terms of the value, and then made a determination from that, or a calculation as to what the 35% would be. And I know Your Honor, Justice Anderson had asked my learned friend, Senior Counsel Mrs. Young, whether if you are to rule that the percent or the approach was not proper, what would be the best method? And we say in these circumstances, the difficulty would still remain because of the lack of availability of records of the company itself to be able to say have a proper valuation put before the court. And as it relates to the Venezuela site home, we say that there was an opportunity for this information to be forthcoming through Mr. Gulab and through Mr. Manmani, who gave evidence, and there was no real value placed before the court by these witnesses. So we say that in the circumstances, what the learned trial judge had before her to be able to arrive at we say just an equitable value for these assets, and thereafter make her determination, we say we're proper in the circumstances.
Thank you, Counsel.
Yes, Your Honor. So that is my final submission in relation to that point, unless Your Honors have any other questions for me.
I see none, Counsel. Please.
Much obliged.
Are you through?
Yes, Your Honor, those are my submissions.
Okay. Thank you very much. And again, we were able to follow you very clearly, and we thank you very much for those submissions. Yes, Mrs. Young, do you wish a reply? You're muted, please.
Obliged, Your Honor, a very short one. As in relation to the issue, my learned friend was asked pointedly if on the 4C it was intended to mean benzer, that wasn't admitted, Your Honor. We say if you look at the pleadings and you look at the amended originating summons, there was an express order being requested of the wife that benzer accounts for the importation of containers, the importation of all containers imported directly or indirectly. And it was the fifth interested party or any company or entity on its behalf during the period 2015 to the date of judgment, and that the respondent paid to the applicant the sum of $2,000 per container after deduction of the sums paid to the applicant. So we say, Your Honor, that just further supports our view that we do not say that there was, we say on the evidence, and now we say on the pleadings as well, that 4C referred to benzer. And the other issue which I wish to address the court on was we would like to reiterate that section 148E, when you look at that section, Your Honor, it deals with the existing title or rights that the parties had at the time of the claim. And we say, again, Your Honor, that unless there is a trustee that separates the legal from beneficial or a declaration in a mini trial within the claim, properly pleaded, that in those circumstances, a beneficial interest could be included in the court when the court is determining what assets are available. We have had an opportunity, Your Honor, to reread the decision of the learned trial judge. And it was clear in her mind, and if I could direct Your Honors to the relevant paragraphs where it starts with, I think it's part D of her decision.
Paragraph?
Your Honor, it's part D. It starts at part D, if I could, and you can find it, Your Honor, at 829. So generally, I'm commending to the court to review that decision, and in particular, when you look at 48, where she's dealing with the Venezuela site home and the shares of benzer, she is dealing with the principles of resulting. She goes into great detail on the principles of resulting and constructive trust. And in that part is where she finds that the husband retains a beneficial interest. But her exposition is this explanation that the court could find a resulting trust. And at page 836 of the record,
What paragraph
She
is that,
says,
Mrs. Young? What
yeah,
paragraph?
it's 48, Your Honor.
48. Yes, yeah, no,
And
okay, good,
48,
yes.
Your Honor, is a very long paragraph, but she breaks it up into paragraph 48, subparagraph I, where she deals with the Venezuela house, and then she breaks it down for the shares under paragraph 2. And she, if I could read with your permission, Your Honors, what she says, and I think this is critical so that you could appreciate what the court was doing in this exercise when she found this beneficial interest that the husband had. She says, before determining whether any beneficial interest subsists in relation to the shares, the court observes that the relief pleaded in the originating summons was not pleaded pursuant to section 148E. So in interpreting the pleading, she was of the view that the claim for the Venezuela shares was not one under 148E. However, as the shares were acquired during the union, section 148E subsection 2 subsumes any jurisdiction the court may have to declare beneficial interest on the general principles of trust. When we read that, Your Honor, it became very clear to us that what she was making was a determination as to the beneficial interest on the resulting trust. So she was holding a mini trial without the parties, we say, being properly before her. And then she makes a finding, and if I could just ask Your Honors to consider for a moment, that she finds that Mr. Lalchand was the beneficial owner of 49. I hear Your Honors when you say that, okay, no order made in this claim is enforceable against the children. But down the road, there is a declaration.
Mrs. Young,
Or
just
there's
help
a
me, please.
finding.
Just help me, please. Is in the operative part of the order, is it before the monetary parts of the order are made? Is this declaration ever stated as and it is declared? Is it ever, apart from the text, apart from paragraph 48 and so, is there any declaration? Is it ever declared in the operative part of the order? Is that ever declared?
There is in relation to Mr. Armanani, but there is not a separate paragraph of declaration in relation to the first to the fourth interested parties, Your Honors.
So when the order was perfected, every court makes orders and the order is perfected and signed off, right? So if you look at the body with judgment.
Your Honor, if I could just direct your attention to the order itself, and you can find the relevant section at page 861 of the record. And this is the order, Your Honor, but it's page 3 of the order. But for your record, it is found at 861. And you look at 4, subparagraph 5. She says, Shyam Armanani holds the legal title to the Venezuela site home. However, the respondent holds a beneficial interest in this property.
You see,
so
in
where
class,
she makes
a
declaration.
Right, yeah, no, I get that. So yeah. See, the thing is, when you make a declaration, generally, it operates in rem, right? You can make an order which operates in personam, but the declaration operates in rem. And I think that's what. All right, yeah, okay. So it's in the order, yeah. Thank you.
Isn't the Mrs. Young? Isn't the transfer of the legal ownership of the chairs, but the retention in the respondent of the beneficial ownership, isn't that also in the order? Because I'm looking at it as part of what I see the order of the trial judge and the judgment. So what you're reading for us isn't just before that in the order. The trial judge deals with the beneficial ownership of the shares in Mr. Gulab, as he's being called.
Yes, Your Honor. So
just read that part first, then.
Notwithstanding the transfer of, I assume this is a section, Your Honor, wishes me to direct my
I think
attention.
that
Yes.
I just want to make sure I have the same thing.
Notwithstanding the transfer of legal ownership of the shares and the respondent retains the beneficial ownership of the shares assessed by the court at not less than 51%. So there is a declaration, Your Honor, that he holds 51 beneficial interest in those shares. And we say, Your Honor, we wish to repeat that to have made such a declaration, Your Honor, the parties had to have been properly. And I just want to correct one thing that my learned friend said in her submissions, Your Honor, and I can't blame her. She was not the attorney who argued on behalf of the wife. There were, out of the first to the fourth interested parties, only 2 had given evidence. The 2 persons were Demi and Nimi. Miriani and Hitesh, of course, was a minor at the time, and they had not given evidence before the court, so that it is not very accurate to say all the parties or interested parties were before the court. 2 had been witnesses, and 2 were named as interested parties, and for Benzer was named as an interested party, Your Honors. So
but Ms. Young, is it
yes.
also correct that even though they all had notice of the proceedings, clearly, but we were told that they themselves never tried to intervene or be joined,
Your
as
Honor,
they could have, right?
Yes, I hear Your Honor, and you did flag that the intervener point earlier when my learned friend was presenting her arguments to you. But Your Honor, when you have an amended originating summons that is addressed to the husband, and you don't say in your release that the first to the fourth interested party holds those shares in trust, and you don't say that Shyam Armanani.
Okay. So in other words, on the face of the OS, the relief claim would not have given notice to the interested parties that their interests could have been implicated. That's your point, right?
That is our position, Your Honor. Yes.
And that would never have manifested itself in the course of the proceedings?
Your Honor, if Your Honor were to look at the arguments, and we, as part of the record, Your Honor, we had included both arguments for the wife and the husband that were put before the learned trial judge. You will see on the arguments, Your Honor, that we were not addressing a beneficial interest as we understood it. And if you look at the interested parties, more importantly, if Your Honor were to look at the submissions of the interested party, they didn't understood the claim to be that the defendant, the wife, was seeking to have a declaration made against the interested parties as the beneficial ownership of the shares.
Allow me to interrupt you for clarification. The wife was seeking to get an interest in the very shares themselves. So not just seeking a declaration in relation to the husband. She was asserting an ownership interest in the company.
I hear you, Your Honor, but one has to appreciate that in the amended originating summons, what was being claimed in relation to the interested parties was that there was to be, the transfer instrument was to be declared null and void as being made to defeat an anticipated order. So when you look at what the interested parties were faced, that was what they understood to be the gist of the claim against them. And that is why, you know, I hear Your Honors, but one has to appreciate that unless there is a claim made against you, there are specific declarations being made against you that you hold these shares or this property in trust, Your Honor. We say respectfully that that would be grossly unfair.
Ms. Young, let me
Under
ask you though, if I may, Ms. Young, let me ask you, you don't appear for the interested parties. They have not. I see that because the notice of appeal is filed by your client only, Gulab Lalchand. Have you, in fact, have the interested parties sought to intervene either in the Court of Appeal or in this court? We have not heard from them, except you, of course.
And following on from
following
on from that question from my sister, Benza was made a defendant, a respondent, and they, as I understand it, applied to be struck out. Who applied on their behalf?
They applied, Your Honor.
Yeah.
There were two applications for strikeout. Yes, at that time it was Ms. Yogini Lochan,
right,
who represented
Benza in relation to whom? In relation to whose shares Ms. Rutilia was seeking an order. Benza says, take me out of this. Benza in relation to whose assets or ownership this lady was seeking an order says, take me out of this. It does not say that we are going to defend your claim of any interest, etc. It is saying that we have no business in this. That's quite striking for me.
Yeah, because, Your Honor, she was seeking an interest in properties owned by Benzer, and that was why in the earlier the earlier originating summons, she had named Benzer as a respondent because she was claiming assets in her original, and we undertake to provide the court with the various iterations.
Mrs. Young, our sister asks a very pertinent question, which is even, you can intervene at any stage, of course, depending on the circumstances justified. And sister asked you that even before this court, there's been no application. Now that we know what the order is, and now that we know what declarations have or have not been made, etc., etc., yet still no one has come before us to say, we want to be heard because there's been some prejudice or injustice to us because of this. You agree? Yeah.
Well, Your Honor, to use the section 148(8)(e), none of this is binding on them. And
none of them seem to be too interested because they know what has happened, one assumes.
Well, I hear you, Your Honor, but
you are very interested for obvious reasons, because
the reason, Your Honor, is because there were consequential orders as to value and monies ordered against the husband based on findings as to beneficial interest in the shares and the Venezuela site property.
But the husband had every opportunity to contest those in these proceedings, which he did. Mr. Gulab, I should say. Yeah. Anyways, all right. Yeah. Thank you very much.
Yes, Your Honor, and we will say that in relation to Webb, Your Honor, we've already put that position before the court. We don't strongly disagree with following Webb under the circumstances. We just, our only position in relation to that is that had there been a proper contest, valuations, disclosures, and so forth could have been marshaled before the court to assist the court in its deliberations.
Thank you, counsel. Is there anything further, or is that your last word?
I don't know if I can be of further assistance to the court, Your Honors, but we will rely on our written submissions filed in this appeal.
Thank you very much, and we'll certainly attend to those written submissions on both sides. And we would like to thank you, both sides again, for the very clear and learned submissions you have placed before us. Naturally, this is a complex matter. We will take some time to consider, deliberate, and we'll have a decision for you as soon as is possible. Thank you once again for your participation. Madam Deputy Registrar, would you call the proceedings to a close, please?
Certainly, Judge. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. Thank you, Mr. Justice Jamada. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you so very much.
Thank you very much.